I have Michael Kuznetsky here, who is a applicant-side workers' comp attorney, which means that he represents workers who want to file workers' comp claims against their employers for work-related injuries. And so today I invited him on because we've been doing a series of COVID-related topics for the public to be aware of. And there's been some changes within the workers' comp world related to COVID-19, work-related injuries. And so we wanted to talk about that. Thanks for spending your afternoon with me, Michael.
Happy to do it. Good afternoon.
I have a lot of questions for you, as I mentioned. We asked everyone on Instagram and Facebook to send us their hot topic questions related to workers' comp that they were curious about. And over the last week, we have broken it down into several categories. So I think we should just jump in. Is there anything that I missed in the introduction that you'd like to let everyone know about your experience and your practice?
I mean, I've been practicing work comp for 14 years now. I did 4 years on the defense side, working with employers and insurance companies, and switched to the applicant side. It'll be 10 years ago this month. So 10 years.
10-year anniversary.
That's right.
That's a long time.
It seems too long. Yeah, that's a crazy number.
So I'm sure you've seen a lot of changes happen within the workers' comp world. Have you seen anything similar to what we've seen with COVID-19?
There's been some huge changes that come from time to time because the way work comp works is it's all based in statute. You have no, let's say, due process rights in the rights as they exist at any point in time. So the legislature can just change them at any point. And there have been a few times since I've been practicing where there's been really significant changes that happened. And they usually get signed in by the governor. The last, there was one in 2005, Governor Schwarzenegger signed one into law, and there's been a couple others. But right now, what we're dealing with is more of an executive order, and I haven't seen anything like this before.
Yeah, I think most attorneys haven't seen anything similar to all the law changes and executive orders and temporary orders in place in the years that we've been in practice. And I don't even think the senior attorneys have seen anything within their career time spans. So it's definitely a new world for us as well. So tell me about, let's keep it very simple for everyone. I want to talk about how workers' comp works in California. If somebody who's watching has no idea and they're an employee, what are kind of the top things that you want them to know about their rights?
So, I mean, work comp, the rights to work comp are set in the California Constitution. So it's an innate right for all California residents. And it covers undocumented workers, and they can't be fired for filing a claim, and nothing gets reported to INS. So every single worker in the state is covered. And that's public policy because we don't want employers exploiting undocumented workers and having them get injured and just have them have no rights. So what work comp represents is what we commonly call the grand bargain. It arises from the Industrial Revolution. Let me know if I'm going too far back here. But nope. The idea is back in the day before work comp, if somebody got injured on the job and they didn't have any money, they couldn't get prompt access to medical care. They had to file a lawsuit, and lawsuits can take years. So workers got sick of not being able to get prompt access to treatment, and employers got sick of being sued all the time. So the grand bargain essentially is that work comp, we're going to create an insurance system where all employers have to have it. And if somebody gets injured at work, for the most part, workers' compensation is their exclusive remedy, which means they're not allowed to file a lawsuit. They have to go through work comp. And in exchange, workers are given prompt access to medical care and other cash benefits, and it benefits the employers because they're not getting sued and it's covered by insurance. Mm-hmm. And the laws themselves are really mostly like in the insurance code and the labor code. And that's really the basis for them, and that's the purpose, is to give people prompt access to medical care.
Love it. So how has everything that's been going on with COVID affected those constitutional rights that Californians have?
Well, the real thing is, everybody has been quarantined for some period of time, and a lot of businesses have shut down. So as far as existing cases go, a lot of the non-essential medical offices have shut down for a period of time. So for example, rehabilitation facilities or certain diagnostic testings like MRIs. So it has slowed the access to the medical treatment, which is supposed to be the main thrust of the system. And then the other thing is that the courts were shut down for a period of time and are now pretty limited. They're only doing things over the phone right now. So that's really slowed the progress of the cases themselves, in addition to the medical care. And then just from an industry, aspect as a whole, there's been fewer injuries overall because most people are working from home, which is great for workers in general. It's been a little slower for my office, but when people aren't going to work, they're not getting injured at work.
So obviously they're not getting injured walking to their fridge. That's not considered a work-related injury, right? For workers' comp purposes, even though they're technically on the job and whatnot.
It could be, depending on what happens. Yeah, the idea of work comp is if you're doing something that benefits the employer, it's covered by work comp. So let's say, you've got a conference call coming up and your throat's a little dry and you need to go to the fridge and get something to drink, and you trip and fall and you break your wrist. That's a work comp injury, even though it happened at home, because you were working and you're going to the fridge to get something to drink was for the benefit of the employer, and the employer should know that people are going to need something to drink. So things like that can be covered, yes. It's more than, yeah, all the types of normal injuries that you would see are still covered in the home. What the difference really is with the COVID-19, because generally speaking, communicable diseases like the cold and the flu are not compensable in work comp. The idea is just that these exist in society. You can't really prove that you got it from work, even if you had a coworker there who got sick. And there's a couple of exceptions that come from really old case law. They're not often used. So the big change is on May 6th, last month, Governor Newsom signed an executive order, which said under certain conditions, if someone gets COVID-19, it creates a rebuttable presumption that the injuries and even death arising from COVID-19 and related complications are going to be deemed work-related for the purposes of awarding workers' compensation benefits. There's a number of requirements for employees to fall into that, but so that's kind of the new thing, is that you have a very common communicable disease like the flu, which is now covered and probably would not have been before.
Interesting. So I think I want to take it back for a minute. So in the big world of workers' comp, what are the two types of injuries? I think it would be good for people to know that it's not only physical injuries that you sustain at work, but also there's a category of non-physical injuries that could be compensable under workers' comp.
Yeah, work comp covers physical injuries, but it also covers certain illnesses, conditions, and industrial diseases. So for example, someone working at a power plant who gets cancer, that would be covered. Or someone who's exposed to an extremely stressful job that maybe has a heart attack. The main two types of injuries that you might be getting at is there's what's called specific injuries and cumulative trauma injuries. And specific injuries are something where it happens at a specific point at time. I fell down and I broke my wrist, a box fell on my head, I got in a car accident, something like that. Continuous trauma injuries are those that happen from repetitive duties over time. Conditions like carpal tunnel, cancer, certain types of orthopedic injuries. I had a woman who was worked in a warehouse painting frames. And, after painting frames for 7 years, she had a lot of shoulder pain. So things like that are covered.
Is stress something that's covered under the cumulative category?
Yes, stress, anxiety, depression, all sorts of psychological diseases, although they're more restricted in the types and how they're covered. So you know, doctors are asked to make absurd findings in work comp where they have to determine what percentage of your stress is from work and what percentage is just from your other life stresses. And in work comp, it has to be more than 50% to be covered. But for example, you know, a bank robbery, right? Someone might come have a nervous breakdown, that would be covered and be fairly obvious. But other ones, someone has just really demanding job and their normal duties over time. Some people have a breakdown and they have too much stress and anxiety and they need medication, and that is covered by workers' compensation, and it's not something that a lot of people know about.
Yeah, I could definitely see people taking on a different style of work than what they were used to from home, and just having the stress of that impact them and bring them to the point of a mild mental breakdown. So that would be something that could be covered under workers' comp, it sounds like.
It could be, although we call them psych claims because they're of psychological nature, and work comp has a lot of abbreviations and acronyms, but psych ones might be hard to prove in work comp, because if you're at home, let's say, and you have a child, and now you have to do your homeschooling and things, that's not really work related, even though COVID-19 is putting you working at home. So, you know, it's kind of the Wild West in terms of those claims go, because none of this has been litigated yet. And there's a lot of open questions with the executive order. But the executive order was really aimed at, well, what happens if someone gets COVID-19? And that was really the thrust of it. And then, yeah, it opens a can of worms for all these other types of related issues.
I see. So let's go back to contracting COVID-19. So the act or the order provides that if you contract it, it'll be a workers' comp claim that you can make. But what if so I'm assuming that these are employees that are on site, or does it also apply to employees that are not on site?
Right, exactly. So there's a number of requirements. So the first requirement is that an employee has performed services at the place of employment on or after March 19, 2020, and it goes through July 15. It may or may not be extended. And they have to be working at the normal place of employment at the employer's direction, which means if they voluntarily went in, that doesn't count. And it's excluded that if the employee is working at home and catches it, that's not covered at all. So, you know, someone who says, their boss says, hey, you're coming in, we're back open, and they catch it, it's covered. If they say, listen, you're working at home and you still catch it while you're working, it's not covered.
What if you have a hybrid? What if you're like, you know, come in twice a week, work at home the rest of the time?
Right, so that's the whole, so what the executive order does is it creates a presumption if all these requirements are met, that it's work related. So normally in work comp, the injured worker has to prove that their injury happened at work. This creates an opposite situation where it's presumed to have come from work, and it's up to the insurance company. They have 30 days essentially to prove that it's not work related, which is really hard to do, right? Almost impossible. So if the employer has someone coming into the office, even part-time, and it falls within that window of time on or after March 19, and they catch COVID-19 and they meet the other requirements, then yeah, it's a work-related injury.
Interesting.
And you know, the main thing with COVID is the complications. There's a what you call it, a doctrine in work comp called compensable consequences, whereas if you have a work injury and then as a result of that work injury you sustain another injury, that new injury is also covered by work comp. So common example, somebody falls down at work and they hurt their left knee. So what's going to happen is, to compensate because it hurts, they're going to start putting more pressure on their right leg. And over time, they might have an injury to their right knee. Well, even though they didn't fall down at work and bang their right knee, the right knee is now going to be covered. And with COVID, we're talking about complications that arise from it. So your average case of COVID-19 is going to be like the flu. Someone's going to miss a couple weeks of work and go back to work, and there's no real claim there. The serious ones are, people who go on respirators, and they're going to come out with, we're seeing heart conditions, lung conditions, kidney conditions, and people with pre-existing illnesses. If the COVID-19 triggers something that was pre-existing, well, the worsening of that original disease is covered. If they die from COVID-19, even if they had pre-existing conditions, that's covered. So yeah, that's what we're seeing and what we're going to see.
So what's required from the employee? So let's, I guess, break down the employer's responsibility first. So the employer is obligated to provide notice, obviously, to their employee that they're covered under workers' comp. What should the employer do when they find out that there might be a COVID-19 case on their staff?
So, yeah, the law on that is really, it's defined by the case law. I'm not going to get too into the case, but essentially, if an employer might know, they don't really have an obligation to do anything. The current standard is actual knowledge. So the employer has to know that a worker is injured and that it was work-related for that to trigger any rights. So let's say you're a manager and your assistant tells you that someone else that they know got COVID, and you know that that person had been in the office during this period, that doesn't trigger the duty to do anything. But if someone says, hey, I got COVID-19 and I think I got it from work, or I think it's part of this presumption from work, that's what triggers the duty. And what the employer has to do is within 24 hours or one business day of being notified, they have to provide the employee with it's a claim form. It's a DWC-1 is the name of the form, and it includes notice of potential eligibility for work comp benefits. So it's basically 2 or 3 pages of information to the employee saying, hey, here's what your possible rights are. And then a written claim form for the employee to fill out and give back to the employer. That's the primary duty of the employer right now is, once they have actual knowledge of a claim, is to provide the claim form.
So, the employer doesn't necessarily have to demand a positive test. The employer, there's no obligation on the part of the employee to go out and prove it to their boss, right?
So with COVID-19, that's part of the executive order is what we just talked about. And there are some testing requirements. So the employee has to have tested positive for COVID-19 or be diagnosed with COVID-19 within 14 days of that period of time that they worked at the place of employment. And the diagnosis has to be confirmed with a test performed by a doctor or surgeon who's licensed in California within 30 days of the diagnosis. So there are testing requirements with COVID-19. And then if it's covered and someone's missing work, they essentially have to recertify within every 15 days that they still have it to continue to receive benefits in terms of wage loss replacement. Now, the claim itself will be covered. Does that make sense?
So that the employee would have wage replacement through the FFCRA, right? They would get whatever 2 weeks of wage replacement, but if they still have it, if they're still testing positive, they can get some wage replacement through workers' comp as well.
Exactly. So the COVID-19 executive order is a little different in that normally if someone's injured at work and if they miss more than 3 days, they're entitled to wage replacement income. What the executive order says is any sick time that someone has that's specifically related to COVID-19, which includes that extra 2 weeks, has to be used up before they get the wage replacement benefit. So the average person probably won't even get there because they'll be out for a week or two, they'll be covered by that sick time, and they'll be back to work before the work comp wage replacement income would kick in.
Gotcha. So that was my next question is how does the FFCRA interrelate with workers' comp? And I think we covered it. And I think we also covered how long, this is a question that we got on Instagram, is how long do I have to report a work-related injury? But we didn't cover, I guess, the length of time for reporting.
Right. What the labor code says 30 days. Within 30 days, it should be reported. Best practices is to report it in writing, although it's not required. But there's a huge exception to that it's one of these exceptions that almost eats the rule, which is that if it's not reported timely, the claim isn't barred unless the employer can show that they were actually prejudiced by the employee's failure to timely report, which is really hard to prove. So, but best practice should be reported within 30 days in writing. Practically speaking, that's what's going to give people the most protection.
Gotcha. And so in addition to the work wage replacement, what are some other benefits that employees get?
Right. So like the main benefit is medical care. And we're talking about prescription medication, treatment, physical therapy, surgery, things like that. There's the wage replacement income. Then there's something called permanent disability, which is after a injured worker has been treating for a certain period of time, they're going to be getting better, and their treatment will plateau at some point. Some people recover fully, but that's not usually how the human body works. There's often some sort of residual effects from an injury. And when they plateau in the treatment, that's called permanent stationary or maximum medical improvement. And at that point, they're entitled to what's called permanent disability benefits. And those are additional cash benefits. And the idea is that we're going to compensate the injured worker for their loss of ability to compete in the workplace and for the effects of the residual injury. Certain people who can't return back to their normal work based on the residual effects also are entitled to an educational voucher where they can go and take classes and get retraining. There's an additional $5,000 tied to that they can get from a fund that's part of the state. And then if someone unfortunately dies, their surviving dependents are entitled to death benefits, which is essentially a cash buyout depending on a number of factors.
So how would the valuations be determined? I know that's a vague question, but if we can maybe use a hypothetical to describe to people, let's say somebody is positive, relatively okay health, but they recover from COVID, but they actually, because of COVID, have some permanent respiratory damage, and their line of work involves them, I don't know, they're a PE teacher or like a swim instructor, and they can no longer go back to the line of work that they were trained for.
Right. So if they can't go back to work, they're entitled to the educational voucher. Now, the permanent disability income is not tied to the fact of whether they can go back to their normal job or not. They're going to get it regardless. And the way it's expressed is in terms of a percentage. You might hear someone be 10% permanently disabled or 30% or whatever. And what that's supposed to represent is a percentage of, so for all the jobs that exist within the state of California, they can't do X% based on their residual injuries. And the way that's determined is it's supposed to be like a formula, but it's actually pretty complicated. So a doctor will evaluate the injured worker once they've reached that plateau, and there's a book that we use. It's the American Medical Association Guides to Whole Person Impairment. And in the book itself, it says, okay, so let me use I don't know, like an elbow injury, for example. If you can't bend your elbow past this point, you have X% what's called whole person impairment. And then we take that percentage, we rate it with the person's age and the occupation they were in when they got injured. And that spits out a percentage of permanent disability. And that percentage then equates to a number of weeks that a person is entitled to a certain dollar amount, and that's how you figure it out. So it's kind of complicated. I've taken whole 3-day seminars just on doing that formula and all the different loopholes.
You didn't go to law school thinking that you'd be doing math, advanced trigonometry and calculus, just to figure out how much your client should get.
Yes, exactly. I don't think anyone goes to law school because they love math.
Yeah. So what happens if a claim is denied? What should the employee do?
So a claim is usually denied because the insurance company has found some reason to deny it. Usually that there's no medical evidence that the injury is from the work. They might say it was pre-existing, or sometimes they might say, hey, they're not an employee. This person was an independent contractor, right? This work comp only covers employees. So all this new variances in the law with AB 5 have a big effect on who's covered. A lot more people are covered now than used to be. But if the claim is denied, the short answer is the injured worker is going to want to litigate that claim. The best way to do it would be to get an attorney. It's really hard to do on their own. Other than, they can get a second opinion. Let's say a doctor says, I don't think this injury is work related. They can get a second opinion, but if the second opinion doesn't work out for them, they're kind of stuck. So the best thing someone should do is reach out to an attorney at that point, because we know how to get around these denials, but it requires litigation. And there's just a lot of, work comp goes deep. Questions that you think might be simple, like how do you calculate permanent disability? They go deep. So getting around a denial, it can go deep, and attorneys are best suited for that.
So if someone does have a work-related injury, whether it's COVID or not, are they in charge and in control of their medical care, or are they obligated to use some of the workers' comp doctors that the insurance carrier is forcing on them?
Right. So most work comp carriers have something called a medical provider network, or an MPN. And it works effectively like an HMO, where they have a list of doctors and you have to choose from that list. And then to get treatment, what the doctors do is they submit a request to the insurance company. The insurance company have their in-house doctors review it and decide if the treatment is medically reasonable and necessary, and if they're going to authorize it or not. And there's certain limited appeal rights. But for the most part, you're stuck. If there's an MPN, they're stuck in it and they have to use those doctors. If there's no MPN, then the insurance company has what's called medical control for the first 30 days after the injury. So they can pick the doctor for the first 30 days, and then the injured worker can pick any doctor they want. And the only other exception really to the MPN is an employee can pre-designate their own doctor in writing before they get injured. So if they do that and they notify the employer that they're pre-designating, and there's certain limits and qualifications the doctor has to have, that's one way that they can get out of the MPN. But a lot of people don't know about it until after they're injured, in which case it's too late. And the law's changed on that a lot too. I mean, when I first started out, employers had very strict notice requirements in terms of notifying the workers about the MPN. And if they didn't strictly comply, we could get out of the MPN. And we did it all the time. And the laws changed and it really tightened up in that regard. So it's very rare now that you get out of the MPN.
So you're basically, you're treating with a physician, and then do you control how long you're treating? Or if the doctor says like, hey, you're fine, go back to work, but you're not really feeling back to normal, what are some things that people can do? Right.
So a lot of people don't know. What happens is very few of my clients get injured and then call me right away. It's not like with personal injury, for example. If someone gets in a car accident, they hurt their neck, their first or second call is to a lawyer. We don't get that. A lot of times, the insurance company will call them and say, hey, we've set up a medical appointment for you. And they don't, the person likes their job. They don't want to create waves. And what the carrier often does is they have these industrial clinics where, these doctors essentially work for the insurance companies. And they might put someone with a legitimate injury and say, you're fine, go back to work. And what the injured workers aren't told is that they can pick any doctor within the network. They don't have to go to that one. The adjuster is sending them to the one that they know is going to give them favorable results. So for example, I just settled a case where I had a client with a broken ankle, and they didn't take an x-ray at the clinic, and they said, it looks like a sprain, go back to work, you're fine. And she said, no, my ankle really hurts, I can't walk on it. You're fine, go back to work. And so they're entitled to change a doctor, they're entitled to a second opinion and third opinion, but a lot of people don't know that, and they're not told that.
Is it within the network that they're allowed to change doctor?
Correct. And there's good and bad doctors in the network, and that's something that's part of the value that attorneys, provide to the case, is saying, okay, let's take a look at this network and see who actually cares about their patients, right? Some networks are better than others, but we're going to find the best doctor that we can for that injury. But it's really, at that point, it's up to the doctor to control the treatment.
And these clinics and these doctors are obviously being paid by the employer's workers' comp carrier, right? So
correct, yeah.
It just doesn't sound fair to me, the system.
It's not great. And then, the other thing you do oftentimes is one side or another might object to a medical opinion. And if the worker is unrepresented, then they're going to go see another type of doctor called a QME, which is a qualified medical evaluator. And they get a list of 3, and the adjuster will say, pick one. And a lot of times the adjuster might even say, we got an appointment for you with this one. And again, these are doctors that, they're very favorable to the insurance company. Let's put it that way. And
it's kind of like it sounds like a no-brainer to me that even if it's the smallest injury, it's to the person's favor to have an attorney representing them, because it seems like the system is so skewed in favor of the employer's workers' comp insurance company that if you don't have that knowledge base, I don't see how you're gonna get proper care, number one, get effective care, and then have it go for the appropriate length of time that you need the treatment, and not just willy-nilly based on a doctor saying, okay, go back to work with that broken leg that is technically a sprain. Can someone actually go, like, let's say in that scenario, if the person in your case was like, you know what, I'm gonna go get another opinion outside of the network, and they go out and they see their own physician, and they get an x-ray done and they have that information, does that come into the case, or does it just give you information to be more demanding with the workers' comp underwriter?
Right. So the second and third opinions you get still have to be in the network.
But it's a free country, right? You could get treatment outside.
So for example, someone's claim gets denied, and they might treat with their own private physician. And that's fine. There's something to be said, and I talk to my clients about this a lot, is that what's good for your case is not always good for your life, right? And what's good for your life is not good for your case. Someone can treat outside the network, but those doctors' reports are not evidence that's admissible. You can show it to the work comp doctors and see if they agree with it or not, or if it'll change their mind. But you can't say my out-of-network doctor said, X, Y, and Z, and I need to show this to the judge. That it can't come in with that.
So it's inadmissible for the case.
Correct. Yeah. And and there's a lot of, I want to say, luck involved in when people choose their own doctors. I mean, not every doctor in the network is bad, and some people, the system was designed to not have attorneys, and the problem is the insurance companies have taken advantage of people and they don't give them all the benefits they're entitled to. They don't tell them everything they're entitled to. And, partly rightly so, because it's a complicated process. Mm-hmm. What happens is, someone might have, and I get these cases too. Someone might come to me and they really like their treating doctor, and they have to go see a QME, and they'll say, I don't know if I want to, quote unquote, sue my employer, but what do you think? And what we'll do is just look, either I know the QME or I'll research them and say, go to this one and you'll be fine. And then they'll just go and continue to do the case themselves. Although the problem is at the end of the case, when you get to the permanent disability part, like I said, that calculation on its face is supposed to look like you plug in some numbers and it spits out a dollar amount. But there's so much wiggle room and there's so much case law in terms of how you get these numbers, how you combine them, what they do, that, you know, attorneys can often add value just from that alone.
Yeah, I mean, it sounds like with the way the system was designed, again, it's no brainer, right? That it's not designed to compensate you fully. It's designed to minimize losses for an insurance company. At the end of the day, they're insurance and they're in the business of making money with the premiums.
Yeah, it's interesting. There was a California Supreme Court case that came out, I think it was towards the end of last year. It's called Skelton. And the California Supreme Court, basically someone said, hey, I should be entitled to wage replacement income if I have to miss work to go to a doctor's appointment. And that went up to the Supreme Court of California, and they said no. And they said the purpose of workers' compensation is not designed to make you whole. It's designed to keep you from being a warden of the state, basically to keep you off the state's tab and to patch you up and put you back to work. So yeah, it's a complicated process. It's not designed to make people whole like you would get in a civil lawsuit, in a personal injury case. So for example, in personal injury lawsuit, there's money for pain and suffering. There's no money for pain and suffering in work comp. And people say, God, but I've suffered so much. And I empathize and sympathize, but there's no money for that. So you really need to maximize all the benefits that you can get, because it's not, generally speaking, a big payday.
Gotcha. So I think we answered some of these other questions we had received, hopefully. We had a question on Facebook, but I think we answered it. I'm not sure, but if we didn't answer, Mike, he's a Mike too, coincidentally. So if we didn't answer your question about Medi-Cal and how it plays in, let me know. The way I understood the question was, can you go to your independent insurance carrier and physician if you're not getting the proper treatment? But if I misread it, let us know. We talked about the DWC-1 form, right? That's the form that the employer gives to the employee that is claiming an injury. What is the Uninsured Employers Benefit Trust Fund? Can you explain that a little bit to us?
Sure. So the law of California is that every employer that has employees has to have workers' compensation insurance, but not all of them do. Some do it on purpose because they just don't want to pay, and some just thought they had an independent contractor and it's really an employee. I just did a trial recently over whether someone was an employee or independent contractor, because they call them an independent contractor, they pay them like one, but they're really an employee under the law. So what happens is, if someone gets injured and they're an employee and it's work related, and the employer doesn't have insurance, a judge can basically bring in the uninsured Uninsured Employers Benefit Trust Fund, or UEBTF. It used to be called the Uninsured Employers Fund, or UEF, and essentially it's part of the state of California that steps in and acts like an insurance company would to pay benefits on the claim and adjust the claim. And then what they do is they go after the employer to recover everything that they've spent. So, the idea is it's not fair to the employee that their employer didn't get insurance. So they should be able to get the benefits that they're entitled to. And they'll get it from the state, and then the state will squeeze the employer. And the state of California is pretty aggressive in collecting when they're owed money. So, from the employer standpoint, it's not a good place to be in, because one, they lose all control over the claim, right? Normally when they have insurance, they might be in touch with the insurance adjuster who's going to listen to them, and the UEBTF, they don't care. But it's mostly the same from the perspective of the employee.
Very nice. I'm glad that's available for people who are employed by employers who aren't really following the law, it sounds like. So can you explain, I know you said that it's not like personal injury where you're not supposed to be made whole, but then we also had that discussion of like permanent disability. So you are being compensated for a length of time, or is it forever? Can we just go over the difference between permanent and temporary in the workers' comp claim, and then the time periods?
Yeah. So what we call temporary disability is wage replacement income. So when someone is injured, oftentimes they have to take time off work to treat and heal. If they need surgery, can't go back to work, they have to be at home. Or if they have work restrictions that the employer can't accommodate. So during that period of time, it's called temporary disability, and they get the wage replacement income. And it's essentially 2/3 of their average weekly wages, subject to certain minimums and maximums. And it's tax-free. So the idea is, it's 2/3, but it could come close to what someone might have received if they received 100% but had to pay taxes on it. And they can get that for a maximum of 104 weeks or 2 years. So that's temporary disability. Some people don't get any, right? Some people get injured and they go right back to work and they don't get any. And some people are off work for 4 years, but they only get compensated for 2 because it maxes out. Under older laws, it used to go forever. People would be, get hundreds of thousands of dollars. Because of the lobby and how much people were making, they capped it. Permanent disability more has to do with that plateau in the treatment, where essentially a doctor is going to say, I don't see this person getting significantly better or worse within the next year. I don't like the name permanent disability because it freaks people out. It's a horrible misnomer because it doesn't mean it's permanent and doesn't mean they're disabled. That's just what it's called. And yeah, in theory, it's supposed to compensate someone for their loss of ability to compete in the workplace. But someone who has a knee injury and has pain in their knee every day, $25,000 doesn't really compensate them for that.
Okay.
That's the idea of the two.
And then permanent, I'm guessing, is like a lump sum, not made to make the person whole, but just enough to adjust the loss of that skill or the ability to compete in the workforce, as you said?
It can be. So there's 2 types of ways, or 3 really, 3 ways you can resolve a workers' compensation case. There's 2 different types of settlements, and then you can go to trial and get an award from a judge. When you get an award from a judge, it's not paid in one lump sum. It gets paid at whatever the rate is. If they're a maximum earner, right now it'd be $290 a week times however many weeks correlate with the percentage of permanent disability, and it'll get paid out on a weekly basis. And when you settle a claim, there's 2 types of settlements. Either way, you get that permanent disability money. In one type of settlement, it's called a compromise and release. It's similar to a civil settlement where the insurance company says, listen, I want to buy out, because that's another benefit that I didn't mention is future medical care. When someone's injured at work, they're entitled to lifetime future medical care. So in a compromise and release, we say, hey, let's do a present day estimate of what your future medical care is worth and buy you out in one big lump sum that includes money for permanent disability and money for future medical care. That's all one lump sum. There's another one called a stipulated award, which is essentially similar to an award you'd get from a judge. It's just both sides agree to it. And what we're stipulating to is the percentage of permanent disability and an ongoing award of future medical care. And those get paid out weekly like a judge's award.
And so are the permanent disability payments taxed?
No.
Opposed to the temporary?
No, none of it's taxable. So anytime, and this is the same in personal injury law, compensation for a bodily injury is not taxable income. In theory, temporary disability should be taxable because it's replacement for wages, but it's not. So that's the main exception there. But no, none of it's taxable.
Interesting. So that's something that I think people always want to know is whether or not they have to report it on their taxes and how it plays in. And then how do the employers, I guess they coordinate with the physicians to decide when the person can come back to work, but how does that work? And then how would it work for COVID related?
So so you have a treating doctor, and they usually give what are called work status reports within every 45 days. And the work status report will say, go back to work with no restrictions, or totally temporarily disabled for the next 45 days, or might say they can go back to work with these restrictions. So no lifting over 25 pounds, no standing or no sitting or standing for more than an hour. And let's say you're released with restrictions. Then that's a conversation between the employee and the employer as to whether they can accommodate those restrictions with their job or not. And now you're getting kind of into the FEHA area, employment area of law, the Fair Employment and Housing Act, where the employer has duties to engage in the interactive process to see if they can try to make some small changes to help them out. So if somebody is released with modified duties and the employer can't accommodate, they're entitled to temporary disability benefits up until they hit that plateau, what we call permanent and stationary. So even if they're able to work, they can still maybe be sent home and given that wage replacement income. But sometimes they can come back and the employer can accommodate their restrictions, in which case they go back to work. And sometimes they might need an ergonomic chair, or they'll put them in a different position, or their position doesn't, let's say an attorney, right? No lifting over 25 pounds. Okay, that attorney can go back to work. They just need to make sure if there's a heavy file, someone else needs to help them out in picking it up.
Interesting. So how, I guess, so for COVID, if you're positive, is there just like a 2-week period where you can come back, or are they really looking to test a few times and get a few negatives before they allow you to come back?
That is something between the employer and the employee. That really falls more in the employment area of law. I know that there's a number of guidelines that have come out about how to put people back safely, and I don't know specifically what that period of time is from the time someone tested positive until they're safe to go back out. But I imagine within work comp, that decision would be made by the doctor. So you'd have to get recertified, every 15 days. And at some point, the doctor is going to say, you're fine to go back to work. And so that's what would that's what would designate it in the work comp world. Now, in the employment world, an employer might say, listen, I don't want someone back on their first day of maybe being okay. And that's kind of outside of my wheelhouse, so to speak.
Gotcha. And then if it is COVID related, if they're just needing to be quarantined and nothing special is being done, right? They're just at home. Can they simultaneously be on workers' comp leave and work from home, like remotely?
No. So if you're working, you can't. Temporary disability benefits are wage replacement income because you can't work. But there's 2 types. There's total temporary disability and total partial temporary disability. And so for example, someone normally works 8 hours a day, 5 days a week, and the doctor says they're kind of weak right now. They can only work 4 hours a day. Mm-hmm. So they can work those 4 hours a day, and then they would get 4 hours of temporary disability benefits to compensate for the difference. But you can't work and get temporary disability at the same time.
Gotcha. Okay. Because it's wage replacement.
Correct. If you're earning wages, you're not getting the replacement.
Which means that if you're feeling good enough to work remotely, you probably don't have a workers' comp claim, or you do because you're technically positive for COVID.
Well, so exactly. So let's say in another scenario, I don't have my own firm, but I work for someone else and I've tested positive and I'm asymptomatic. The employer's not going to let me come back to work, even though I feel fine. So what that means is they're going to send me home. And if I can't work from home based on what I do, I'm going to get temporary disability benefits or sick pay, depending on how long I'm out for. But it's not up to the employee alone. So the employer has to also be able to put them back to work. And if they say, listen, we can't accommodate someone who's COVID-19 and feels great because our office is too small, or we're just not that, we're not willing to take that risk, then they can send them home until, they can bring them back when they're feeling better, when they're no longer contagious, I guess.
Very nice. Well, I think we covered all the questions that we got. I always ask, is there like a piece of advice or just one thing that you would want to put out there for employees to be aware of, or even employers to know amid everything that's happening?
So for the employers, it's a little easier. Is a lot of them don't know about the duty to give that claim form. They don't really get in trouble for it.
The DWC1.
DWC1 claim form. They don't know it, and they don't get slapped on the wrist. Nothing bad happens. But what happens is, if you don't give the DWC1 claim form when you should, the statute of limitations never starts running. So that means someone can come back 10 years later and file a claim if they, have a legitimate claim. Mm-hmm. And normally that would have been barred. So for the employers, it's important to give that claim form because they want to start the statute going. So at some point they have some finality as to when a claim can be brought. For employees, I think I mentioned it earlier, and it's worth noting again, if someone thinks that they're injured and that the injury is related to their work, they should report it in writing. It's not required, but it's best practices, because I get into these situations all the time. I'm actually set for trial on Monday, and this is one of the issues is, did the employee tell the employer that they had a work injury? Because the statute of limitations is an issue. And it's kind of, it's not in writing. So, the injured worker, my client says, yeah, I told him. And then the employer says, he never told me. And in any area, if you have an email or anything in writing that you can show to a judge and say, look, I told him, here, check out this email. That makes very strong evidence. Even though it's not required, it's gonna put people in a very strong position to maintain their claim.
Very nice. So thank you, Michael, for joining me today. I think that covered all the questions that we got, some of the ones that I was curious about. Again, I'm going to put your information in the description box for anyone out there that wants to reach out to Michael. Do you provide maybe free consultations, or how does it work with your office for potential clients wanting to call and ask you questions?
Yeah, always give free consultations. And I oftentimes, not everyone needs an attorney. I know the gut check is, hey, best practices is get an attorney, but not everyone needs one. And sometimes I'll tell people, if their claim's going well and everything's on the up and up and the insurance company is doing what they need to do, it's rare, but it happens. And I'll just give them whatever advice they need and let them go. But regardless, always free consultations. And, when we take a claim, it's never, we don't get paid by the injured worker up front. What we do, we work on a percentage and get paid at the end of the case. So it doesn't matter if someone has any money or not. And I'm happy to talk to people about any questions they might have. I mean, it's the reason I like workers' compensation. I've done a lot of different areas of law, and work comp is my favorite because it's the only thing I've done where I feel like I'm actually helping people. And so if someone can, get a little bit of advice and be helped out, I'm happy to do it.
Awesome, very nice. So I'll put your information, your office address and everything in the description box. I want to also disclaim for us here that we're not providing any legal advice to any of you out there. We're just doing this for fun to get information out. If you have specific questions, then definitely reach out to Michael. Don't reach out to me for workers' comp issues. I can't help you. Call his office. Thank you so much for taking the time, and I hope all of you found this to be helpful.
Yeah, thanks for talking with me about it, and I hope there's some good information there, and that I hope it wasn't too complicated the way I'm explaining it, but some of these concepts are pretty complicated and go deep. So
No, it was
yeah.
perfect. I loved it. It was perfect. Have a good weekend, everyone. Bye-bye.
All right. Thank you. Take care.